Good evening, ladies and gentlemen, esteemed participants, and distinguished guests. It is with immense honor and profound respect that I stand before you today at the Dr. Ashok Kumar Mohapatra Memorial National Moot Court Competition 2023. Today, we are privileged to welcome Mr. Sanjay Kumar Subhabrat Acharya, working as an Assistant Endowment Commissioner, Cuttack, along with Mr. Kumar Spandan, Civil Judge, Kendrapada. Distinguished judicial officers who have graciously agreed to adjudicate this round of our moot court. Their presence here is not just an honor, but a testament to the high standards and the spirit of excellency that this competition embodies. On behalf of our Dr. Ashok Kumar Mohapatra Memorial Committee and all the participants, I extend our heartfelt gratitude and a warm welcome to our esteemed judges. Your presence elevates this competition and inspires us all to strive for the highest ideals of the legal profession. Now, with your lordship permission, we may start this round.
Proceed.
Obliged. Please. AKM 6, please, who is your speaker 1 or speaker 2?
Actually, we are using the same device, a speaker one and speaker two. So is that fine?
Yes. Yes, yes.
Okay.
Specify the time, please.
Yes, we have bifurcated as speaker one will be taking 15 minutes, speaker two 10 minutes, and 5 minutes for rebuttal and solve.
Okay, petition. Okay, respondent, please.
Excuse me, I'm sorry. It's 20 minutes for speaker one and 15 minutes for speaker two.
No. 10 minutes.
This round is for
We
40
have
minutes.
30 minutes.
Okay.
Okay. So sorry. We have 40 minutes. Okay. For
Yeah,
speaker 1, 20 minutes, or speaker 2, 15 minutes, or 5 minutes for
15
rebuttal.
minutes.
Okay.
Yes.
Respondent, please.
We are the petitioners. AKM 06
This
are the
was before.
respondents.
Oh, yes. I'm asking about respondent.
AKM 6 is the respondents. AKM 7 is the petitioner.
Actually, the time application I provided to you was from the respondent side. AKM 06 is
Okay.
the respondent.
Okay, petitioner, please.
Yeah. AKM 7, 18 minutes speaker 1, 18
Okay.
minutes for speaker 2, and 4 minutes for the rebuttal.
Okay. Thank you. Please proceed.
The council seeks permission of the honorable dice to proceed.
Yes. Proceed.
With your honor's permission, the council seeks permission to refer the honorable benches, your lordships.
Sorry.
The council seeks permission to refer honorable benches, your lordships.
Yes.
Greetings to the dice. May it please the honorable court. The council here is present for the petitioners in the case of Chandler, Monica, and others versus Union of Silverland, under the jurisdiction of Article 32 of the Constitution of Silverland, filing an PIL from the side of Monica and Chandler, and one code nation. The council seeks permission to proceed with the facts of the case.
No, directly go through the points.
Indeed, your lordship. The council in the present context will be firstly dealing with 5 issues in the present context. Issue 1 and 2 will be dealt by me, and issue 3, 4, and 5 reading with UCC adoption rights and LIC claim will be dealt by my co-counsel. The council seeks permission to proceed with the arguments of the case.
Yes.
Your lordships, in the present context, the issue 1 will be dealing is whether the maintainability of the PIL that has been filed by my clients, that is Monica and Chandler, and other client that is one code movement. The organization that is protesting for the Uniform Civil Code implementation. The councils humbly submitted that in the present, both the PIs are maintainable before this honorable court. The council will be proving the arguments in the context of 3-4 arguments. Firstly, the council will be proving the maintainability of Chandler's and Monica PIL. And secondly, the council will be proving the maintainability of PIL filed by one court motion. And thirdly, the issue that is dealing with is whether the implementation of Uniform Civil Code is feasible or not. Dealing with maintainability of PIL filed by Monica and Chandler, it is submitted that in the present case, the PIL that has been filed by Chandler and Monica is in regards for the recognition of same-sex marriage, as they have been rejected to accept the marriage or the union that they have been after the recognition of same-sex relationship in 2018. And such relationship, after that recognition, Monica and Chandler in the present case got married, and they take a plea that as the constitution of as the Supreme Court of Silverland has decriminalized and given the access to form a same-sex relationship, they can come up and get married. But what happened with my clients is, your lordship, they have been rejected to accept and register their marriage. The council humbly submitted that in the present case, under Article 32, my clients have right to file a PIL. Clients have right because there has been the infringement of the fundamental rights that are governed under Part 3 of the Constitution of Silverland.
Okay.
In the present case, what has happened, my lordships, is the direct infringement, and there is an involvement of general public importance question of law, and secondly, the substantial question of law. The council will be proving that in the present case, we are not we are considered with case of Monica and Chandler, but if your honorable court will give the recognition to same-sex marriage, it is directly connected with rights of thousands of homosexuals that are eagering, or they want that same-sex recognition should be sex marriage should be given the recognition. That clearly proves that there is an importance and there is a recognition of general public importance question of law. And in the case of plethora of cases and various judgments by the Honorable Supreme Court, as stated as CCE versus Standard Motor Products, N. Suryakala versus A. Mohandas, Haryana State Industrial Corporation versus Cork Manufacturing Corporation, the Supreme Court has humbly accepted that when there is an involvement of general public importance in the question of law, there is a jurisdiction and the court can entertain the PIL filed by the petitioner. Moving on to the substantial question of law. Substantial question of law is not defined in the legislation, but while interpreting it, the Constitution Bench in the case of Sir Chunnilal Mehta and Sons Limited versus Century Spinning Manufacturing Corporation Limited, Your Lordship, please refer to page 15, para 6 of my moot proposition. It's in the highlighted part, in the italic section, the Constitution page 15, Your Lordships.
15,
page 15.
Okay.
Paragraph
Chunilal Mehta case, huh?
Yes,
Century
yes, Your
Spinning.
Lordship.
Okay, okay.
Where the court has interpreted what a substantial question of law and what is the test to define the substantial question of law. The court highlighted that the proper test for determining whether a question of law raised in the case is substantial would be one opinion be whether it is a general public importance. That in the present case we have already proved that the matter involves the question of general public importance. Secondly, whether it directly or substantially affects the right of the parties. Your Lordships, in the present case, my clients Chandler and Monica are directly and substantially implicated because of their infringement of fundamental rights.
Okay.
And as it fulfills the test suggested by the Honorable Constitution Bench, as suggested in the case of Sir Chunnilal Mehta, there involves a substantial question of law in the present case, Your Lordships. Moving on to the next point that the council would like to proceed with is the infringement of fundamental rights. How my clients' fundamental rights are infringed and how they have the right to file a PIL. In various cases, in the recent landmark judgments, the Supreme Court has accepted the relationship between same-sex gender. say it
Hmm.
Navtesh Singh Johar case, say it Nalsa versus Union of India. All these cases, including with KS Puttuswamy versus Union of India, there
Hmm.
has been given a recognition that same gender people have right to be in the relationship. Also, Navtesh Singh Johar case decriminalized Section 377 that
Hmm.
permits the sexual intercourse between the same-sex gender relationship.
Hmm.
When the Honorable Supreme Court has given such a right, along
Hmm.
with when we take a judgment of Shafeen Khan case, where it was given that a person has right to choose whom she can marry or whom he can marry. That right to choose a person, if that has been given to a person, and if we are denying in the present context that you cannot choose a person to whom you want to marry, it is a direct infringement and direct negligence of the orders of the Supreme Court that has been already passed in various landmark judgments. So
Hmm.
it directly proves that in all circumstances, my clients are being inflicted by the restriction by not registering their marriage. To
Hmm.
sum up the whole issue in the present case in relation to PIL that has been filed by Monica, the council would like to refer the case of Romesh Thapar. The Honorable Court may please refer to page 19, para 22 of the Moot proposition.
Yes.
Page 19, para 22, where the case of Ramesh Thapar versus State of Madras has been stated. It
Hmm.
clearly sums up how Article 32 is applicable. Article 32 provides a guaranteed remedy for enforcement of these rights, and these remedial rights in itself made a fundamental right being included in Part 2. This
Hmm.
court is thus constituted to protector of and guarantor of fundamental rights, and it cannot constitutionally, with the responsibility so laid down upon it, refuse to entertain applications seeking protection against infringement of such right. So
Hmm.
Ramesh Thapar case make a consensus that in the present case, my clients have the
Hmm.
maintainability. Moving on to the
Okay.
PIL that has been filed by one code movement, that is in relation
Hmm.
to the uh, implementation of Uniform Civil Code in the state of Silver Land. It
Hmm.
clearly implicates that why. Firstly, we have to understand why there is a requirement of Uniform Civil Code in the nation. Uniform
Hmm.
Civil Code that has been given recognition in under Article 44 of the Constitution of Silver Land, that
Hmm.
comes under the directive principles.
Hmm.
But in the present case, we want a recognition, and this requirement comes because of this violation of Article 14. Article 14 of the Constitution talks about the equality before law, the equal protection
Hmm.
of law. A person who is a citizen of India should be
Hmm.
treated equally, and they should be given
Hmm.
an equal protection before the law. If there would be
Okay.
an implementation of Uniform Civil Code restricting the other personal laws that has been created, this diverse laws create a confusion that has been in the present context. Implementation of Uniform Civil Code will bring a consensus between these all laws. We are not demanding that the articles protecting freedom of religion under Article 25 to 28 should be infringed. They are there to protect the religion. We are demanding that Article 14, that is comes under the basic structure of the Constitution, as held in the
Hmm.
Keshananda Bharti case, that
Hmm.
basic structure of the Constitution should be protected. That should be protected, and UCC does is feasible to be implemented, and hence the matter involves the feasibility of Uniform Civil Code, and it governs the public at large. The PIL, thus filed by One Code Nation movement, is
Hmm.
thus
Hmm.
maintainable before this Honorable Supreme Court, Your Lordship. That in
Okay.
consensus bring to the light that both the PILs are maintainable. Firstly, because of the
Hmm.
violation of fundamental rights in the case of Monica and Chandler, and secondly, the public interest that has been involved in the case of Uniform Civil Code in relation to PIL filed by One Code movement. If the Honorable Court
Okay.
is justified with the issue one, yes, Your Lordship, please.
Yes. See, can you just tell me what is the definition of we are right now dealing with a case of LGBT, right? So,
Yes.
can you just tell what is the definition of trans man and trans woman? and where it has been dealt with?
The definition of trans men and trans women was dealt in the case of Navtej Singh Johar case, where they were recognizing
Yes, yes, yes,
what is a
yes.
trans man and whether they
Hmm.
have a right of being in the relationship. So, when
Just speak the tell the qualities, main issues by which we can say it is a trans man or such a person is a trans woman. What are the basic fundamental things?
major differentiation that is between the
Hmm.
trans men and trans women is that the trans
Yes.
men has majorly the manly quality, but they are implicated in such a character that they also persist of women qualities like the figurely structure, and that is the major difference that
Okay.
has been created by the Supreme Court. Same as the trans women, they consist of
Hmm.
majorly the women's quality, but the
Hmm.
features, the body physiques, and all the characteristics that has been defined as per the US reports that has been considered is Navtej Singh Johar case, the psychological reports that has been considered in the US reports that has been the psychiatric research the US reports has
Yes. Yes.
considered,
Correct.
and
Correct.
Navtej Singh Johar case has considered that, and according to that they
Hmm.
have differentiated between trans men and trans women.
Yes. Yes. Okay. That's very good.
If Honorable Court is issued one, the Council seeks permission to proceed with issue two, Your Lordship.
Yes. Yes.
Indeed, Your Lordship. The issue two that is we are dealing with relates to recognition of same-sex marriage in the present case, Your Lordship.
Hmm.
Whether same-sex marriage can be recognized legally, and does Constitution protects their right. In that regard, the
Hmm.
Council will be submitting the issue in two sub-issues. Firstly, the
Okay.
constitutional protection that has been under the fundamental rights that has been given, and secondly,
Could you
there's
please
a
just let me know the page in which issue
indeed, Your
number
Lordship.
two has been dealt
Issue
with?
two deals with page number 22, Your Lordship.
Yeah, the
Uh,
proposition is too long, so it's quite difficult to find out the pages. Okay, not an issue. Page 22. Yeah, got it.
Page 22 of the
Yes,
memorial.
yes, yes, yes.
So we're dealing with two sub-issues: that the constitutional protection that has been given, and secondly, if we recognize same-sex marriages, there's neither a
Hmm.
violation of any of the fundamental rights. In that regard, for the first sub-issue, it is submitted that the constitutional protection that has been given, if we
Hmm.
plainly read Section 5 of Hindu Marriage Act, what
Hmm.
it says that a marriage between a Hindu person, it in neither regard state that whether that person is a transgender, a man, or a woman.
Hmm.
So, in a
Hmm.
plain reading, there is no restriction that has been provided to that interpretation under Section 5 of the Constitution.
Hmm.
And no other such provision, if we read any of the provisions, no such wide discrimination has been done. There's a structural consensus that has been made, and in the
Hmm.
plain reading, it is very clear that there's no differentiation that has been created. Also, if we come under the decision of again the Navtej Singh Johar case, they
Hmm.
have recognized the protection of sexual orientation under Article 15 of the Constitution.
Hmm.
Article 15 that we are dealing with, Article 15 states about the protection or the protection that has been given and the discriminate against the discrimination, which is based on
Hmm.
the sex, caste, gender, relations, and color and creed. In Navtej
Hmm.
Singh Johar case, the Supreme Court interpreted that sexual
Hmm.
orientation should be also protected
Hmm.
under Article 15. There's no such
Okay.
differentiation that has to be created, because if we
Hmm.
create such a differentiation on the
Hmm.
basis of sexual interpretation, it will be direct infringement of Article 50 that protects against right against discrimination. So
Okay.
this protection has been granted to the transgender peoples. Sexual orientation,
Hmm.
if we consider, sexual orientation includes in all regards the transgender men, transgender women, and all the other categories that come under LGBTQ plus. All
Hmm.
the other categories are being protected under Article 14. Similarly, if we
Hmm.
are talking about Article 14, Article 14 protects the equality before law and equal protection of
Hmm.
law. And as
Hmm.
already established in the issue 1, that if we are not giving such a recognition, it will be directly implicating my client as well as all the other peoples that are in relation to this case would be affected, because indirectly or directly if we are recognizing marriage of my clients, it will give set a precedent by this honorable Supreme Court that other people who have the right should have the right to claim it with proper precedent set by this honorable bench. So, if there's a consensus that has
Then
been
what
made,
is the definition? Is there any definition of man? Is there any definition of man?
uh, uh, not a strict definition that has been defined what is a man. There's no legislature definition that is. If we read IPC
Hmm.
sections define man, and when the definition of that man under section 2,
Hmm.
it also
Hmm.
states that man includes women.
Yes.
So, if man includes women, then why we should deny that man should also include trans women, trans men?
No, no. You are right now by stating why if IPC provides man includes women, then
Indeed,
it would also mean man includes LGBT. This is your presumption, right?
indeed, Your Lordship.
This is your assertive presumption. Huh.
Uh,
Is
uh,
there is there any judicial pronouncement to that effect?
Indeed, Your Lordship. The Nalsa versus Union of India case that has been pronounced in the same
Okay.
regard. The Nalsa
Okay.
versus Union of India case was dealing with
Hmm.
such a similar issue of same-sex gender recognition. In that regards, when the Honorable Supreme Court was discussing the matter, the Supreme Court has discussed that when we are interpreting, we should not be in the strict interpretation that should be followed. A harmonious construction should be have given, and such harmonious construction should create such a relation that every type of gender, including the sexual orientations, should be given a
Hmm.
recognition. And
Hmm.
if we are recognizing sexual orientation, then a sexual orientation ultimately will be including transgender men and transgender women in that regard, Your Lordships.
That means irrespective of the fact regarding the genitals of a human being, either in case of man or woman. Huh? You are saying the man in this context, the man includes transgender, right? It
Indeed, Your
is your
Lordship.
assessment. Huh? Okay, okay, okay. Okay, proceed. Go on.
Indeed, Your Lordship. Proceeding ahead, when we are dealing with why recognition of same-sex marriage will not violate the fundamental rights. To give
Hmm.
that a basic argument on that regard, firstly, I would like to call upon various personal laws that has been created, the objectives of various acts. Uh,
Yes.
Indeed, Lordship may please refer to page 25 of the memorial, para number
25.
44,
Yeah.
and the
Yes.
continuing paragraphs, where I've
Hmm.
highlighted Hindu Marriage Act, the object of the
Hmm.
act what it states. The preamble
Hmm.
says that an act to amend and codifies the law relating to marriage among Hindus. It
Hmm.
is nowhere indicating men and women. Similarly, moving to next paragraph in the next page, Special
Hmm.
Marriage Act has been considered. An act to provide a special form of marriage in certain cases for the
Hmm.
registration of such and certain other marriages and for divorce. Here also no definition that strictly for men and women. Similarly, considering Indian Christian Marriage Act, Foreign Marriage
Hmm.
Act, same things have been highlighted. It is relating to
See,
marriages.
in all these legislations, you will
Indeed,
find a common word that is called marriage.
indeed, Your Lordship.
Okay. Where marriage has been defined.
The marriage has been
Is there any definition of marriage under
indeed
statutory law?
indeed, Your Lordship. Hindu Marriage Act defines marriage as a
Yes.
solemnization of men and women. That is in the
Yes.
strict regard that has they have been followed.
Yes. In Hindu Marriage Act, it is provided that marriage means the solemnization between a man and woman.
Indeed, Your Lordship.
Okay. Then,
We
what
are
is your argument in this?
indeed, Your Lordship. We are not neglecting the fact that in the current scenario, there is a strict stating that man and woman should be married. What we want is the recognition of such and the more broader aspect. Because when the act was created, there was. Should I proceed, Your Lordships?
Yes, you can proceed.
Indeed, Your Lordship. So when this whole scenario of things was created, it was a very late interpretation that has been given. The silver land country is a developing country, and with developing nature we have to adopt to such a situation where the recognition of sexual orientation should has been also considered, and that is the amendment we are considering in the present regard. When Hindu Marriage Act was enacted, transgender relation was not such a prevalence at that stage. But with a developing society, there is a need that a transgender woman and transgender men should also be considered, because they too also have a right. They should also get a right in cases of marriage, recognition of their marriage, in relating to adoption, in various claims of LIC matters. That are the matters in the present case too. My clients have
Hmm.
been denied the right to adoption. Why? Just because their marriage is not recognized. My clients has been recognized the LIC policy that solely indicated that my client was the sole nominee, but also then my clients were rejected. Why? Because there was not recognition of marriage certificate. There was an absence of marriage certificate. This totally indicates that there is a direct infringement of rights and lordships. And if same-sex marriage should be given the recognition, it will directly create a scenario that everyone should be treated equally, and they will get a equal protection before this honorable court, the court of country. The constitution
Hmm.
will be protecting these
Hmm.
people, and it is very
Okay.
necessary that such a protection should be given. Uh, if we consider Article 19(1), what it regards is the freedom in the case of speech and expression. Now,
Yes.
how marriage is considered in a case of speech and expression, it is submitted a lordship. The council asked the court permission to refer to page number 26, lordship.
Yes.
Page 26, para number 47. I would
Okay.
like to reiterate it. Article 19(1) of the Constitution of Civil Land guarantees all citizens a right to freedom of speech and expression. This includes
Hmm.
right to express one's gender and sexual identity, which may be done in married ways, including words, action, behavior, or any other form. That has been accepted in the case of Navtesh Singh Johar. The Supra 22 italics is related to Navtesh Singh Johar case, Your Lordships.
Hmm. Hmm.
A next line that is for main important: a marriage is an expression of love and commitment and should be covered under the freedom of expression that has been protected under Article 19(1)(a). This has been
Okay.
identified in the Navtesh Singh Johar case. It is a settled precedent that the court has already preferred and said that protection under Article 19(1)(a) should be given, and
Hmm.
marriage should be given such a protection. So, hence, if we are protecting marriage, giving all the rights, we are giving a right for same-sex relationship. And to recognize such a relationship, it is very necessary that a solemnization of two people should be done, because ultimately all the rights that has been granted to a union is after the recognition of their marriage. So if
Hmm.
we are creating a gap between these rights and the recognition of marriage just by
Hmm.
stating that you have a right for your relationship, but if you get married, that is your choice, but we didn't give you right and the legal recognition of such marriage, this ultimately infringes or takes away all the rights that has been given after the union is solemnized. So it
Okay.
clearly states that in all consensus, if we give a right to all our clients, it will, in including with all the peoples of your country of civil land that are in category of transgender women and men, they have the right, and this will create a social implication, and such rights should be given. And hence, in all
Hmm.
conclusion, the council will like to submit that same-sex gender marriage should be recognized, your lordships.
Okay.
That is my humble
You
submission.
referred. You referred the Specific Marriage Act, right?
Indeed, your lordship.
Yeah. In Specific Marriage Act, in accordance with your para number 44, you have stated refer two statutes, Hindu Marriage Act and Specific Marriage Act. Specific Marriage Act provides it's an act to provide the aim of the act is, as you have written, an act to provide a special form of marriage in certain cases for the registration of such and certain other marriages and
And
for divorce.
indeed, Your Lordship.
Okay. Okay. So in this context, I would like to ask ki, if specific marriage act provides marriage between man and woman,
Indeed, Your Lordship.
irrespective of any caste, any creed, any religion.
Indeed, Your Lordship.
Okay. Okay. Then whether my question is, in this particular matter, in this particular case we are dealing with right now, is there any necessity for amendment of specific marriage act
Uh,
in this regard?
Indeed, Your Lordship. Why we are asking for such amendment? If we are
Yes.
considering a situation, Hindu Marriage Act was adopted for Hindus. Muslim Marriage
Hmm.
Act was
No, no,
adopted
I
for.
am not concerned about Hindu marriage act.
Uh,
Just tell me whether any amendment is required under specific marriage act in this present context for
Indeed,
the
Your Lordship.
giving, as per your version, the legitimate right of the LGBTQIA. Okay.
Indeed, Your Lordship.
Is there
There,
any amendment required?
indeed, Your Lordship, there is a requirement of
Yes.
amendment in the Special Marriage Act because
Okay.
if there is a union that has been recognized, if Honorable Supreme Court recognizes same-sex gender relationship,
Hmm.
that will come under the relation of Special Marriage Act because it is
Yes.
will be creating a category of special marriage that has been defined under what
Yes.
a special marriage is. So,
Hmm.
considering that transgender men and transgender women's union or a civil union will coming under the Special Marriage Act, and they can claim
Yes.
the rights such as of rights of maintenance, rights of adoption, right of divorce that has been granted, that will be
Hmm.
covered in the Special Marriage Act. So, if we will be giving the
That means
recognition,
amendment is required. Okay.
indeed, Your Lordship, there will be a
As per
requirement.
your submission, amendment is required for giving rights to the present issue, to the
Indeed,
persons who have been denied.
indeed, Your Lordship.
So, if amendment is required, so my next question is, the amendment is to be done by which agency?
Legislature is the sorry.
Yes, legislature is the, here comes the doctrine of separation of power.
Indeed, Your Lordship.
Which article?
Article separation of power
Yes.
under article has been governed under Your Lordship. Uh, just
Okay, let it. Okay.
I
So,
will
if
conclude.
doctrine of separation of power comes into play, then we cannot encroach each other's area, right? The
Indeed, right.
role of executive, the role of legislature, the role of judiciary is fixed. So,
Indeed, right.
if, and in your version, if amendment is required for a specific statute, it is the exclusive domain of legislature.
Indeed, Your Lordship. Now coming
Okay.
on to
Then in this context, in this context, where does the locus standi regarding maintainability of this PIL stand? You got me? You got me?
indeed, Your Lordship, I've got your point.
Yes.
Now coming on,
Yes.
the main question is whether the legislature can be infringed by the judiciary. Now
Yes.
coming to that point, we are not demanding that judiciary
Whether
should come.
my simple question is whether we can do
Supreme
the
Court has the
job,
power to.
whatever has. Yes.
Indeed,
Proceed.
Judge. Talking onto that, Supreme Court doesn't have a power to infringe upon that. They cannot jump into the
Yes.
shoes of executive or the
Yes.
legislature. But
So was that of
Supreme Court
legislature.
has the power to give directions, Your Lordship. It can issue
Okay.
various writs under Article 32, that is the extrajurisdictional power under 32, that can be referred. And now, coming into that case, like when a Supreme Court, whether a Supreme Court has power to give a guidelines, considering the case of DK Basu versus State of Bank, that the case relating to preventive detention and the criminal arrest of an accused. In that case, the Supreme Court has given guidelines on how a person that has been arrested should be kept upon. Such encroachment can be done where the Supreme Court has power to give guidelines. The same is
Hmm.
the demand in the present case. The Supreme Court has power to frame a guideline. When the Supreme Court has given the guidelines in DK Basu case, that guidelines paved the way to form a Preventive Detention Act and make an amendment in the Preventive Detention Act. In the similar manner, if the Supreme Court in
Hmm.
the present context give a certain
Hmm.
guidelines, Supreme Court being the highest judicial authority in the country of Silver Land has the authority to give guidelines, and a order or a direction given by Supreme Court is binding upon the country, and hence a direction that will be issued by honorable bench will be a precedent that will be set. And DK Basu case justifies such statement that a guideline can be given. A similar case will be Vishakha case. That in that case
Hmm.
also Supreme Court issued guidelines regarding to the issue.
Hmm.
A same can
Hmm.
be done in the case of various judgments that have been provided in relation to IT Act, where Section 66B was cancelled out. The Supreme Court
That has been
allowed
struck down in a
struck
single
down.
case. Okay.
Share a
No,
single
no.
case.
If we were dealing with doctrine, if we will be talking about doctrine of separation of power, then another issue comes before this, before this court for consideration, the concept of judicial review.
Indeed, Your Lordship. Uh,
Okay. In present context, does doctrine of separation of power bar the power of judicial review of this court?
uh, Before moving ahead, the council seeks
You
permission
you
of the
you, you
court to
got my
proceed.
point.
Yes, indeed, Your Lordship, I've got your
Ah,
point.
yes,
The
yes,
council seeks
yes.
time before this court because my time is already over. Dealing with the present
Okay,
question
okay,
that is being
okay,
dealt
okay,
with, I will
okay,
just take 30 seconds to deal with the separation of this power. The separation of
okay,
power has
okay.
been dealt under Article 50 of the Constitution, Your Lordship. Referring to
Yes, yes.
Article 50 that has been suggested upon, talking about that, what the heading of Article 50 states: separation
Hmm.
of judiciary from executive. It doesn't
Yes.
say separation of judiciary from legislature. It
Hmm.
also said the state shall take step to separate the judiciary from executive in public services of the state. It clearly implicates
Hmm.
that judiciary give guidelines and can issue orders to judiciary by the to the legislature to form a laws, and
Hmm.
legislature considering the orders that has been given act upon it, and such can be
Okay.
done in the present context. That is my humble submission, Your
Hmm.
Lordship.
Okay. Okay.
If the,
No, no. My question remained unanswered.
uh,
My question was: does the doctrine of separation of power bars bar the power of judicial review of Supreme Court?
no, so Supreme Court has the power of judicial review, Your Lordship. Under various
Okay.
judgments that has been
Okay.
struck,
Okay. Okay.
the Supreme
Thank
Court
you.
has power.
Under which article judicial review is provided?
Uh, article uh, Article number 13, it has been provided with judicial
Yes.
review.
Very good. Very good. Very good. Okay.
Yes,
Okay.
yes. The council wants the my co-council to proceed with other three issues, Your Lordship.
Yes. Yes.
It was honor
Proceed.
arguing before this court, Your Lordship.
Your Honours, the Council seeks permission to proceed with the issues number 3, 4, and 5.
Yes.
Much obliged,
Proceed.
Your Honours. The Council, under issue number 3, would be dealing with the issue which states that does the Uniform Civil Code infringe upon the individual's fundamental and personal rights as protected by the Constitution of Silverland, and does it present an overreach of the state into the personal laws of its citizens? The counsel for the petitioner most humbly submits that adoption of a uniform civil code will in no way infringe upon the fundamental or personal rights of the citizens that have been guaranteed by the Constitution of Silverland. Also, this will
Okay.
not lead the state to the infringement or overreach of its authority. The council humbly submits that or these basing upon two major grounds. Firstly, the
Hmm.
presence of constitutional validity of the Uniform Civil Code. And secondly,
Hmm.
that the Uniform Civil Code does not infringe upon the fundamental and personal rights of the individuals. Your Honours, considering that Silverland.
I think you are not audible. Ms. Counsel, you are not audible.
Ignorance for that, Your Honours. Can I continue?
Okay. Yes, yes.
Much
Proceed.
obliged. So, Silverland is a very diverse nation which recognizes Saath Fere and the sacred fire, as well as
Yes.
Nikah and Nikah Nama, holy matrimony
Hmm.
and the wedding vows, Anand Karj and the Guru Granth Sahib. Further, the constitution of the Silverland emphasizes upon justice, liberty, equality, and fraternity under the preamble of the constitution. So considering these two heads into a single cone, the adoption of a uniform civil code will not take away any of the above enshrined rights. Neither will it thrust one's community's personal code on the country as a whole. This unified framework respects the diversity of the traditions while upholding the fundamental rights of the citizens that have been guaranteed by the Constitution of Silverland. The Uniform Civil Code
Hmm.
is provided as a directive principle of state policy under Part 4, Article 44 of the Constitution of Silverland, which states that the state shall endeavor to secure the citizens a uniform civil code throughout the territory of India. The idea of UCC,
Is
Your
it
Honor,
44
is,
or 144?
Your Honors, it is Article 44 under Part 4 of the
Yes.
Constitution.
Okay.
Much obliged, Your Honors. So, this idea
Hmm.
of UCC, Your Honors, is based on the concept of secularism and to endorse the concept of equality before law as is enshrined under Article 14 of the Constitution of Silverland. Your Honors, the same was held by the Honorable Supreme Court in the case of Sarla Mudgal versus Union of India, which has been referred by the Council
Yes.
under para 44, page 29 of the Moot Memorial.
44.
54, Your Honors. Para 54, page 29.
Para 54. Page
Yes, Your
29.
Honors.
54. Yes, yes. Sarla Mudgal says. Yes.
Your Honors. Moving ahead, Your
Hmm.
Honors, understanding the implication of UCC through a mathematical analogy, it could be said that the application of set theory is applied in the case of a uniform civil code, where the uniform civil code, after its application, would be acting as a superset to all the other religious legislations that are currently in force in the nation, which would act as a subset to the uniform civil code if applied in the nation. Your Honors, the Uniform Civil Code aims to ensure parity for all the citizens in matters of personal laws concerning marriage, divorce, succession, guardianship, etc., guaranteeing equality that has been provided under Article 14 of the Constitution of Silverland. Further, Your Honors, UCC would encompass some major legislations which have been provided under the Hindu Code Bill, that is the Hindu Marriage Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act. Also considering the Muslim Personal Law, that is the Shariat Act. Following ahead, the Special Marriage Act. So all these personal legislations would be combined under one head where no any religious activities would be curbed, but certain specific or uniform legislations would be carved out for all the religions to follow, maintaining equality among all and providing them or guaranteeing them the fundamental rights and the personal rights that have been provided under the Constitution. Also,
Hmm.
Your Honors, UCC aims to filter out the bias and irregularity from the personal laws and provide one fair and secular civil law for all. As under many
Okay.
personal laws, it is seen that there is infringement of their rights, where marriage has been considered only between a man and a woman. Further, a woman has
Hmm.
been considered as underrated, where women are not provided the same rights as that of men. In several maintenance
Okay.
cases, women have to suffer the most. Thereby, we see that
Hmm.
personal laws are also not guaranteeing those fundamental rights that have been provided by the Constitution to each and every citizen. Your Honors, a uniform civil code is considered as a sine qua non to eradicate the
Hmm.
violative characteristic of all the personal laws that infringe upon the right to equality of the citizens. It emphasizes on removing all these irregularities. Your Honors,
Hmm.
the Supreme Court, through several judgments, have emphasized that a uniform civil code can help in the national integration, which was held by
Hmm.
our Chief Justice Y.V. Chandrachud in the case of Muhammad Ahmad Khan versus Shah Bano Begum. The same has been provided
Yes.
under page number 33, para 61 of the Moot Memorials, Your Honor, where it has been
Yes.
considered that
Yes.
uniform civil code is a basis to the national integration of the nation, which is the need of the hour, Your Honors. Further, personal laws need to reform with time and the changing society as it is recognized. As women are the inferior sex, but through several acts of the judiciary, it is taking a transformative turn. Whereas also in the case of Shaira Bano versus Union of India, it was held that religions or the religious personal laws need to take a turn from the rudimentary characteristics that they have, and uniform civil code could act as the only solution where all the fundamental rights and the personal rights could be considered. Also, Your Honors, implication or application of the Uniform Civil Code would not act as an overreach by the state. This could be considered by the right provided under Article 25 of the Constitution of Civil India, Honors. From the plain reading
Hmm.
of Article 25 of the Constitution, Your Honors, it is seen
Hmm.
that subject to public order, morality, health, and other provisions. This term
Hmm.
subject to states that, Your Honors, if the state has been provided the authority to implement Uniform Civil Code as a DPSP under Article 44, it could also act or restrict the right provided under Article 25 of the Constitution, subject to the provisions of morality, health, and public order. Here, in the present case, Your Honors, my clients Chandler and Monica have been, their fundamental rights have been vehemently violated as they are not provided or their marriage has not been recognized. Further, their want of adoption is also not being recognized as they are not being provided. Also, after the death of Chandler, Monica is not being granted her LIC claim. All these are sheer violation of the fundamental rights that are been provided to each and every individual, and only on the mere basis that implication of UCC would be violative of the fundamental rights or the personal rights, it is not to be considered, Your Honors, as the state has the authority to infringe upon the or to restrict these rights as provided. Further, Your Honors, when there
State
is
has the authority to infringe.
Your Honors, not to infringe
State,
but to restrict, Your Honors.
yes, yes, yes,
Yeah, to restrict the right, Your Honors, under certain
yes.
considerations to keep it in the interest of the majority of the people.
Okay,
Your
okay.
Honors,
Mr.
also
Counsel,
when there is,
you
Your Honor,
just referred I think the Uniform Civil Code enshrined
Your
in
Honor,
Article 44 of
44.
Constitution. So these are directives, right? DPSP.
Your Honors,
Huh?
Your Honors.
So my question is, if Uniform Civil Code will be applicable to the India throughout the India, as per your submission, it will be helpful in the
Your
present
Honors,
context to all the
Your Honors,
persons concerned, huh, which
Your
will be
Honors.
helpful as provided Article 14. Okay, then if DPSP will, in the form of Uniform Civil Code under Article 44, coming under DPSP will be provided, huh, then can it be enforceable as that of fundamental rights?
Your Honors, as we
Because
consider it,
the DPSPs are not enforceable. Huh.
Your Honors.
Whether a person can go directly approach the Supreme Court under Article 32 or High Court under Article 226 for encroachment of DPSP, as that we are going to Supreme Court or High Court if in case of breach of fundamental rights. You got my point?
Yes, Your Honors, I got your
Yes,
point.
yes. What is
To
your
answer
submission to
that
that effect?
question, Your Honors,
Yes.
to answer that question, as we consider that DPSPs are not in itself enforceable, but when there is a tussle between the DPSP and the fundamental rights of the principal through several judgments of the Supreme Court, it has been stated that there needs to be a harmonious construction between the fundamental rights and the DPSP. And also, it has been
Yes.
laid down in the case of Keshwananda Bharti versus the state of Kerala that harmonious construction has to be taken as the prime consideration where the fundamental rights of the citizens are at stake. And DPSP could be made enforceable by a harmonious construction of the same with the fundamental rights that have been guaranteed to its citizens, Your Honors.
Okay, okay,
Your,
okay.
Your Honors, under those heads, the Council contends that implication of a uniform civil code in the nation of Silverland would be the sole thing that would regard the rights, the fundamental rights and the personal rights that have been provided by the Constitution of Silverland to all the communities, including the community of LGBTQIA plus community, whose rights are majorly at stake in the present situation. Also, these implications of UCC, which only act as a restriction in certain cases where the public morality or the interest of majority of the people are at stake, would not act as an infringement or overreach of the power of the state in the certain cases. Thereby, Your Honors, it is contended that UCC needs to be implemented. Moving ahead, Your Honors, the Council seeks permission to proceed
Is
with
there any difference between fundamental right and legal right?
Your Honor's fundamental rights are those rights which have been provided or guaranteed under the Constitution of a nation, and legal rights could be
Okay.
provided through any of the statute of the state. Your Honors.
Okay. Thank you.
Your Honors,
Proceed.
proceeding with the fourth issue. The fourth issue deals with the refusal to give the adoption rights to the LGBTQIA+, which amounts to the violation of their rights. The council humbly submits that a refusal or causes a violation of their right, and it is contended majorly basing on four grounds, Your Honors. Firstly, that there is a presumptive character of the CARA guidelines. Secondly, that adoption being regulated by the Juvenile Justice Care and Protection Act. Thirdly, that equality is a cornerstone of the basic structure. And fourthly, that non-grant of the adoption right distracts their right to family. Your Honors, under the first ground, it is humbly submitted that adoption is a permanent parent-child relation which is established where the child as well as the parent simultaneously get benefited, where a parent who are not unable to conceive a child would be getting a child, and a child who is an orphan not having the right, the care or protection of a parent would be getting the care and protection of a parent. Your Honors, the Central Adoption Resource Authority, CARA, is a statutory entity under the Ministry of Women and Child Development, which provides the regulations. So, under the Regulation 5, Clause 3 of the CARA guidelines, it provides that no couple can adopt a child unless they have at least 2 years of stable marital relationship. Your Honors, my clients have been denied their right of adoption majorly basing on Regulation 5.3 of the CARA guidelines. But Your Honors, it is to be considered that Regulation 5.3 is just having a presumptive character. It only assumes that the couple would or would not, that if adoption rights have been guaranteed to an LGBTQIA plus couple, they would not be having a stable marital relationship. Your Honors, to that consideration, our Chief Justice D.Y. Chandrachud have held in the recent case of Suprio versus Union of India. Your Honors, it could be referred from page 36, para 74 of the Moot Memorial,
Yes.
that law cannot make assumption about good or bad parenting, and it perpetuates a stereotype to the heterosexual couples. Thereby, Your Honors, considering that an LGBTQIA couple would not be having a stable marital relationship for 2 years, only upon this guideline restricting them with the right of adoption is not valid, Your Honors. The right is being provided to an individual uh, unmarried person, but the same is not being provided to a married trans LGBTQIA couple. This differentiation is not a reasonable differentiation, Your Honors, and thus violative of Article 14, the right to equality of my clients, Your Honors. Further, Your Honors, it is contended that the Juvenile Justice Care and Protection Act deals with the adoption, where it has been, through several judgments, stated that adoption should be considered in the best interest of the child, Your Honors. In the present case, Your Honors, the guidelines governing adoption of children 2015, which have been provided, it does not mention anything about the sexual orientation of the parents, but the only consideration that has been provided under the JJ Act of 2015, it is not at all in compliance with the rights that have been provided and is completely ultra-wise, as there is no reasonable differentiation between an unmarried person and a married couple who are not being provided with the right of adoption. Also, Your Honors,
Hmm.
referred in para 61, page 38, the case of Navteej Singh Johar versus Union of India, where it was held
Hmm.
that sexual orientation is considered as an integral part of the right to privacy and dignity. Where this
Hmm.
is an integral part, only denial of their right of adoption under the consideration that they would not be having a stable marital relationship by the Kara guidelines that have been provided is a sheer violation of their fundamental rights, Your Honors. Further,
Okay.
it is also considered that equality is a cornerstone of the basic structure doctrine, Your Honors. So, this
Hmm.
regulation 5.3 has failed the test of reasonability, Your Honors. Also,
Hmm.
the Nalsa versus Union of India judgment had held that non recognition of their identity as transgender man or woman is violative of their fundamental rights under Article 14 and 21, as they are completely denied a dignified life. Where Article 21, under the meaning of life, also constitutes a dignified life that has to be provided to each and every individual, Your Honors. Your
Yes.
Honors, where in the case of Geeta Hariharan versus the Reserve Bank of India, provided under para 89, page 39 of the Moot Memorial, Your Honors, if Your Honors could refer, this case
Yes.
has strictly regulated that the regulation 5.3 of the Kara guidelines was held to be ultra vires, as it is not a reasonable differentiation that has been created between a married couple and the unmarried person who could adopt, thereby denying my clients the right of adoption only as a consideration
Hmm.
that they belong to the LGBTQIA community is a sheer violation of their fundamental rights, and their right to life has been
Hmm.
completely violated, Your Honors. Your Honors, their
Okay.
right to dignified life is not being considered. Further, Your Honors, the impression, their denial is under the impression of an inferior family, where there are no any
Hmm.
such reports to support that an LGBTQIA couple would not have a perfect family, or they would not be able to provide the same rights as it has been provided to the child of a heterosexual couple. Therefore, this
Hmm.
consideration is completely presumptive in character and is a sheer
Okay.
violation of their fundamental rights under Article 14 and 21, Your Honors,
Hmm.
thereby denying the rights to my client Monica and Chandler under this consideration is a sheer violation of their fundamental rights. And this regulation of the Kara under Regulation 5, 3, Clause 3 is not to be held as, not to be upheld as valid, and it should be held as ultra vires, Your Honor, as these are not in consideration to the fundamental rights that have been guaranteed by the Constitution of Silverland. Your Honors, moving ahead, the Council seeks permission to proceed with the fifth issue of the case.
Okay. Proceed.
Your Honors, under the fifth issue, the Council contends
Only one
that
question. One question. You said you referred. I think you referred Article 21 of Constitution, right?
Your
Right to
Honors,
life. Huh?
Your Honor.
Right to life. Huh? In which case it has been decided that right to life includes right to life with dignity.
Your Honors, in several cases, where in the case
What is the
of,
landmark one?
okay, Your
Yes.
Honors, if considering to that case, the landmark case under Article 21 is that where right to life includes the right to dignity through several cases
Dignity.
where
Yes.
the golden triangle has been considered. In Menka Gandhi case also it was held.
Yes.
Further,
Yes.
in
Yes.
the
Okay. Okay.
recent,
Go ahead. Go ahead. Go ahead with fifth one.
Your Honors, Your Honors, under the fifth issue, the Council would be proving that the denial of the claim to my client Monica based on the infringement of a marriage certificate, based on the non grant
Hmm.
of marriage certificate, is an infringement
Hmm.
of her right and entitlements. The same is proved majorly basing on four grounds, Your Honors. Firstly,
Hmm.
that there is denial of her right as a sole beneficiary. Secondly, there is
Hmm.
denial of her right of inheritance. Thirdly, there
Hmm.
is violation of her right to life. And fourthly, there is no such exquisite requirement of a marriage certificate under that claim. Your Honors, under para 15 of the Moot proposition, the problem that has been of the present case, Your Honors, it is
Hmm.
clearly
Okay.
provided that Chandler had designated Monica as a sole beneficiary in the life insurance to ensure her financial stability. When someone is
Hmm.
designated as a sole beneficiary in a document, Your Honors, they are entitled
Hmm.
to inherit all the assets that have been covered under the document. Your Honors,
Okay.
uh, a sole beneficiary has a legal claim to all the proceeds that have been provided in the document. They have the right to sell or transfer them if they choose to do so. Your Honors, the council seeks 2 more minutes to complete this argument.
Yeah, sure.
Much obliged, Your Honor. Hence, Your Honor, if a person has not been designated as a nominee but a sole beneficiary, it states that a sole beneficiary has a legal claim to all the proceeds and the right to sell, to transfer, or to deal with the property that has been mentioned under the document. But a nominee has no legal claim to the assets and they cannot sell or transfer them also. Thereby, Your Honors, Chandler had a foresighted view in naming Monica as a sole beneficiary, but not only as a mere nominee to his life insurance claim. Further, Your Honors, there is a consideration of the doctrine of vested interest, where once the
Hmm.
interest under a claim has been vested, no insurance company has the right to deny it to the person who has interest under that claim. And under that consideration, Your Honors, the same has also been reiterated through in several other nations as well, Your Honors. The doctrine of vested interest was first recognized in the nation of United States. Your Honor's denial
Yes.
of my client's Monica's right on the consideration that the presence or the non-presence of her marriage certificate is not to be considered as valid, as she has complete vested interest being a sole beneficiary of the life insurance. The same was also iterated in the case of National Insurance Company Limited versus Keshav Bahadur and others, provided under para 105, page number 44 of the Moot Memorial, Your Honors, that the insurer
Okay.
cannot hold the insurance back. Your Honors, moving
Hmm.
ahead, that it is a denial of a right of inheritance. The right of inheritance has also been considered under several legislations in the nation, Your Honors. And where a
Hmm.
person, the definition of a person when referred from the General Clauses Act, it states that in connotation of person, these provisions apply to any person, not being just referred as a male or a female. Thereby, just the denial of them being regards that they belong to the LGBTQIA plus community is not to be considered, as the General Clauses Act specifically provides the definition of persons under the laws of inheritance
Hmm.
is not only to be restricted to a male or a female, Your Honors. Further, Your Honors,
Okay.
disqualifying a gender on the ground of gender identity is not justified as per Section 28 of the Hindu Succession Act as well, Your Honors. Your
Hmm.
Honors, there is a sheer violation of the fundamental right, the right to life of my client. Your Honors, she has a right to claim. Being a transgender person has right to life includes the right of every individual and every citizen of the nation, Your Honors. Also, Your Honors, in the case of LIC of India and others versus Consumer Education and Research Center, provided under para 111, page
Hmm.
45 of the Moot Memorial, Your Honors, if there is
Hmm.
non-grant of LIC of life insurance claim to a beneficiary, Your Honors, on a non-reasonable ground, then it is a sheer violation of their fundamental rights provided under Article 14, 19, Clause 1, and Article 21 of the Constitution. Also, Your Honors,
Hmm.
it is referred from para 5 of the Moot proposition, Your Honors, that the
Hmm.
wedding between Chandler and Monica was done embracing their individual religious rights. Thereby, Your Honors, under that
Okay.
consideration, a marriage certificate is not always essential to be a proof of their marriage when it is in regards to their religious ceremonies, Your Honors. Your Honors, the same have been also reiterated in the case of Shafeen Jahan versus Ashok and KM, where where there is a right to marry to the person, and if there is a denial to the person basing upon the claim of non-grant of a marriage certificate when the marriage has been recognized in observance of their religious rights, is a sheer violation of Article 21. Thereby, Your Honors, it is humbly submitted that non-grant of the LIC claim to my client Monica is a sheer violation of her fundamental rights, and it should be held that she should be granted the right under the insurance claim, Your Honors. Your Honors, the counsel seeks permission to proceed with the prayer of the case.
Okay. You just referred the Special Marriage Act, marriage performed under Special Marriage Act, right?
Your Honors.
But under Special Marriage Act, the marriage which is being performed, it is called a civil contract, isn't it?
Your Honors. Your Honor.
Then in this point, you said there is no particular definition of marriage and anybody can marry anyone else under Special Marriage Act. My question is, if under Special Marriage Act, marriage is a civil contract, and there is no necessity for ceremonies or saptapadi or sacred fire, putting vermilion, whatever is being observed.
Your Honor.
Then,
Indeed,
then,
Your Honor.
In this present case, as you have been denied your right to choose your life partner, to get the material benefits of the LIC, whatever. The question is the specific Marriage Act, and you have referred another legislation, Transgender Persons Protection Right Bill.
Your Honors.
Under Transgender Persons Protection of Right Bills, you have stated it provides the recognition of right to claim insurance.
Your Honor.
But Specific Marriage Act, under Specific Marriage Act, a marriage certificate is necessary.
Your Honor.
So if a marriage certificate will not be provided before the concerned authority, then is there any modalities to prove that A and B are married? Suppose A and B are LGBT. Okay. Is there, what are the modalities? What are the forms to prove a marriage under Special Marriage Act?
Your Honors. Answering to that question, Your Honors, if an LGBTQIA couple have been married under a Special Marriage Act and there is a non-grant of the marriage certificate to the couple, Your Honors, in the present case, it could be referred from para 5 of the Moot proposition that there was solemnization of a marriage with regards to their individual religious rights in presence of their close relatives. Your Honors, when there is presence of the close relatives, their presence act as evidence of the proof that yes, their marriage was solemnized. Also, when a question arises as to a validity of their marriage, whether it was recognized as per all the religious rights or not, there are certain considerations where Your Honors, my audible.
Yes, I am audible.
Your Honors,
you are audible, please.
Your Honor, there are certain considerations where the religious rights, where it is under the religious, where the marriage has been solemnized under the religious rights, considering their religious rights, there is no requirement of a marriage certificate. It has also been reiterated by the Supreme Court through several cases that if a religious rights, their performance of saptapadi, certain essential things that have been provided under those rights, Your Honors, a marriage certificate could not be considered as a ground of disregarding the solemnization of their marriage. Also, Your Honors, in the present case, when there was presence of their close relatives, and it was in honoring of their individual personal rights, Your Honors, it could stand as a stand where it could be said that their marriage was solemnized as per the rights that have been provided to them, Your Honors. And thereby a marriage certificate is not an essential thing to be.
That means, according to you, marriage certificate is not a sine qua non for proof of marriage under Specific Marriage Act.
Yeah, indeed, Your Honor.
Okay. Thank you. Proceed. Go ahead.
Much obliged, Your Honor. Moving ahead with the prayer. Wherefore, in the issue facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed and implored before the Honorable Supreme Court that to issue an appropriate order declaring the PIL filed by the petitioners are maintainable before the Honorable Supreme Court. Issue an appropriate order declaring it feasible to implement the Uniform Civil Code. Further, issue an appropriate order between QI plus as further to issue an appropriate order declaring the implication of UCC not to infringe upon the individual's fundamental or personal rights. Also, to issue appropriate order declaring that the refusal to grant the adoption rights to my client as a violation of their fundamental right, and also to recognize that the denial of the insurance claim in non-presence of a marriage certificate is an infringement of her rights. Therefore, also pass any other order, direction, or relief as the court may deem fit in the interest of justice, fairness, equity, and good conscience. The counsel addressed the case, Your Honor.
Okay. Am I audible, Mr. Counsel?
It was a pleasure arguing with.
There is one question. Am I audible?
Your Honor, you're audible.
Yes. Coming to the same question, doctrine of separation of power, does it come in the way of issuance of direction of Supreme Court regarding to protection of fundamental rights?
Your Honors, through several judgments, it has been laid out that Supreme Court has the authority to provide guidelines, whereupon the state, in consideration to those guidelines, has the authority to formulate the legislation. Therefore, it is not at all an infringement of the doctrine of separation of power. Separation of power in this nation is not considered as strict separation of power, but a permeable separation of power, where there could be considerations, which is also governed through a doctrine of checks and balances between all three government systems, Your Honors. Providing guidelines by the Supreme Court, as it was also held in the Bishapa guidelines case, Your Honor, it's not an infringement of the doctrine of separation of powers.
Okay. Thank you. Thank you very much.
Your Honor.
Whether the respondent will start or time is yet not over for the petitioners. Can it be clarified by the court master, please?
Am I audible, sir?
Yes, yes, yes.
Yeah, respondent, you can, your time starts now. You can say.
Okay.
Speaker one and speaker one, especially. How many times you will be taking speaker one?
Sir, it was 20 minutes for speaker 1, 15 minutes for speaker 2, and 5 minutes for rebuttal and surreport.
Okay. So as per the discretion of the court, if the court time exists, it's not an issue. Alright? Okay. Thank you.
Okay.
Thank you.
Warm greetings to the Honorable Bench. This is Counsel 1 appearing on behalf of the respondent. The Council seeks permission from the Honorable Bench to address as your Lordship.
No, no. Whatever you prefer, you call. Not an issue. Huh.
Much obliged, your Lordship. The Council for Respondent seeks permission to proceed with the issues. So, issue 1 and issue 3 would be dealt by Council 1, and issue 2 would be dealt by my co counsel, and including the prayer.
Yes.
The issue 1 raises the question whether both the PIL are maintainable in the Supreme Court of Silverland or not. It is humbly submitted before the Honorable Bench that both the PIL are not maintainable under the grounds that they have alternative remedies available, and the PIL is since both Monica and One Code movement have alternative remedies available to address their concerns, such as for Monica, the state may contend that the state has other legal avenues to pursue the claim for the life insurance bond, such as providing additional evidence or appealing the decision without amending the prayer. Similarly, One Code movement may be advised to pursue legislative avenues and or engage in public advocacy for the rights of the Muslim women. And also, the PIL is not maintainable under the grounds that they involve complex societal and legal uh, religious issues that require nuanced considerations and uh, interpretations. And the courts might have urged to exercise the caution in entertaining the PIL that is seeking broad legal changes in the aspects to provide legal rights to the LGBTQ community, especially here the alternative remedies are available, and these channels that the remedies are available for addressing those grievances as filed by the petitioners. And also the PILs encroach upon the separation of powers between the judiciary and the legislature, as the matter related to legal reforms such as the introduction of a unified legal code are within the legislative domain, and the court should refrain from making the sweeping changes through PILs. Another consideration is the religious freedoms, that is one of the fundamental rights as guaranteed under Part 3 of the Constitution. One code movement's PIL is not maintainable as every person, every where has the right to freedom of thought, conscience, religion, and belief, including the freedom to change their belief or not to believe, and introducing a unified legal code. Could potentially infringe upon the established rights under personal law, especially in society with a significant diversity of faiths and religious essence. And a unified legal code might infringe upon the concerns about and the concerns about possible infringement on religious tenets and practices can be raised to resist the implementation of the unified legal code.
Okay.
And
If UCC will not be applicable, according to you, Mr. Counsel, if Uniform Civil Code will not be applicable, isn't it violative of Article 14 of Indian Constitution, which speaks about right to equality in broader concept, broader aspect,
no, Your Lordship,
including Article,
the
so also keep in mind Article 14, Article 19, Article 21,
yes, Your
which are
Lordship.
called as golden triangle of Indian Constitution, isn't it? Isn't that
Lordship.
violative of these three articles upon which our Indian Constitution stands?
No, Your Lordship, this won't lead to violation of right to equality before law, or neither right to the Article 19 and 21, as the fundamental right, it is the discretion of the court, and also the it is the Supreme Court has declared that this is the discretion of the state. It is guaranteed under the Article 44 of the DPSP, whether to implement UCC or not. So it is not violative of any fundamental rights, and also the rather it is violative of fundamental rights when it will be implemented, as the to practice the religion and faiths is guaranteed under the Part 3 of the religious the fundamental rights only. The constitution has guaranteed the right to practice religious faiths and other essence related to it. So UCC might have the implementation might lead to the infringement of the personal laws as well as the religious practices.
So far as my memory is concerned, you just referred at your initial time, uh, personal laws, you emphasized on Muslim law.
Yes, no, Your
Why
Lordship.
Muslim law?
Your Lordship, I haven't referred to the Muslim law. However, the PIL was filed for the Muslim women.
Yes.
So I refer the Muslim women that um, uh, the PIL filed by the One Code movement is not maintainable, as every person has the right to freedom of thought, conscience, and religion
Okay. Under article?
under Article 25.
Yes. Proceed.
Much obliged, Your Lord. If it may please Your Lordship, I would proceed with the further arguments.
One more question. As previously stated, in this context, cannot this court rather, or Supreme Court, issue certain guideline for clarification upon a subject which is coming under directive principle of state policy,
Yes, Your Lordship, it can.
as
But
held in the
however,
case
it
of
is
Vishaka referred by the petitioners. I am referring to the case of petitioners, right? They,
yes, Your Lord.
can a court cannot a court issue guidelines
Your Lordship, it can issue
instead
the
of guidelines?
guidelines.
Let it be directives. It will be proper
Yes,
directives.
Your Lord. Yes,
Yes.
Your Lordship. But but according to Article 44, it is
Yes.
the discretion of the state whether to implement those guidelines or not. It is not the binding directives.
Okay. 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 Proceed. Proceed.
Yes, Your Lordship. So the PIL filed by Chandler and Monica may not be maintainable due to the issues relating to the legal standing and availability of the alternative remedies. It is to consider whether the couple has exhausted all available legal avenues before resorting to a PIL. Since Chandler has passed away, Monica's claim for disbursement of the death benefit from the LIC is a personal grievance and does not warrant to PIL. So this matter can be resolved through regular legal proceedings as well.
At which
And
forum they will? At which forum they shall knock for their legal rights? If not
your
at this stage, not at this court, then what is the appropriate forum for approaching the petitioner?
your lordship, they would this case would fall under the civil case.
Civil suit.
Yes, your lordship.
Okay. Okay. Proceed.
So the and also the court should be cautious about interfering in the policy matters, especially those related to the marriage, adoption, and family laws. And as these issues are traditionally within the legislative domain, as stated under the uh, Supriyo Chakravarti versus Union of India. In this case, it was held that these issues are traditionally within the legislative domain, and the court may be urged not to overstep its bounds. And regarding the locus standi, there is lack of locus standi, as one code movement lacks the locus standi to file a PIL on behalf of the Muslim women's rights. As an organization, one code movement may not demonstrate a direct and personal interest in the matter, making the PIL non-maintainable. So it is the both the PIL are not maintainable due to the availability of alternative remedies, personal grievances, and the lack of locus standi. So, and the
Okay,
denial
you
does
referred
not.
you referred courts shall not interfere in policy matters.
Yes,
Okay,
Your Lordship.
certain a policy has been made. Let's assume a policy has been made. Okay, in that policy, there are certain norms which exclusively violates the fundamental rights under Article 14. At this
Yes, yes.
juncture, is it not the duty of this court to issue and to interfere by issuing certain directions, certain clarifications?
Indeed, Your Lordship. The person, in this case, in case of the violation of fundamental rights, the person can move to the Supreme Court under Article 32 to
Mhm.
protect their fundamental rights, and under or under Article 226 to the High Court.
Article 2?
26 to the High
Yes.
Court.
Okay. But you have specifically mentioned the matter of marriage, adoption, and family laws. If
Your
such
Lordship, in
things,
the
yes, yes,
yes,
yes. Proceed.
yes, Your Lordship, in the case Supriya Chakravarti versus Union of India, it
Hmm.
was held that the matters relating to marriage, adoption, inheritance, all these personal laws come under the ambit of the legislation. This is the part of the legislation only.
Okay.
Okay. So, and also it is humbly submitted before the Honorable Court that equality under Article 14 means that all persons should be treated equally, no matter where
Hmm.
they are, whether they are poor or rich, male or female, upper caste or low caste. However, this state cannot provide any special privilege to anyone in the country. However, the court, while giving the test of reasonable uh, classification, in the case Ramkrishna Dalmia Justice versus Justice Tendulkar, described that the jurisprudence of the equality before the law, and that there is a dependable assumption in favor of the constitutionality of a rule, and that is the burden is upon the who upon him who attacks it to demonstrate that there has been a reasonable transition of the constitutional standards. And since Article 14 forbids the class legislation and not reasonable classification, the distinction between man, woman, and transgender does not amount to irrational classification. Similarly, Article 15 talks about the prohibition of discrimination on the grounds of gender and not grounds of sexual orientation. They haven't faced the discrimination on the grounds of gender, regarding their gender identity.
Okay.
And this,
Is the word husband or wife has been defined in any statute?
yes, Your Lordship, under the Hindu Marriage Act, it has been defined.
Okay. Okay.
So the Article 15 Clause 3 provides the for the special provisions for women and children, thereby implying that Article 15 does not uh, Article 15 covered by the only woman in its ambit. And there has been no discrimination made against the petitioners, and there is no violation of their fundamental rights, as the discrimination is reasonable and they have not been discriminated due to their gender identity, however the sexual orientation, which is reasonable in nature.
Sorry.
and
The sexual identity?
and not sexual orientation.
Okay. Yes.
And Article 19, which talks about the freedom of speech and expressions,
Mhm.
comes within the set of reasonable restrictions on such freedoms, such as the freedom to express does not mean that one can alter the boundaries of morality and decency. The test of compelling the state interest was satisfied, and whether the enforcement of morality is sufficient enough to restrict the fundamental rights or not, since decency or morality as constituted as one of the grounds of restrictions on freedom of speech and expression under Article 19 Clause 2.
Hmm.
In the case Ranjit D. Udekshi versus State of Maharashtra held that the courts needed to balance between the freedom of speech and public decency and morality. Hence,
Hmm.
allowing same sex marriages is against the principle of morality. Since the concept of marriage has been emerged from the religious concept, it is the religious sacrament,
Hmm.
whether it is Hindu religion or any other religion. It recognizes marriage between the male and female only. If it may please your lordship, the council would like to proceed with issue number 3.
Under Hindu Marriage Act, it is
Yes, your
provided
lordship.
marriage is being solemnized in between male and female. Hmm.
Yes, your lordship.
Then what about Special Marriage Act?
Your lordship, Special Marriage Act provides the marriage is a civil contract
Yes,
between the.
contract can be made between any persons.
However, there has been it has not been explicitly mentioned that any person such as those LGBTQ community, which includes the 72 other genders, can also pursue the right under that.
Then isn't it violative of Article 21, right to life with dignity?
Your lordship, the council seeks ignorance.
Okay,
Uh,
okay, okay, okay. You proceed, you proceed.
So the issue number 3 raises the question that is the refusal to give adoption for LGBTQ couple a violation of their right?
Yes.
The respondent, the council on behalf of the respondent humbly submits before the court that the decision to refuse adoption to the LGBTQIA couples is in accordance with the existing adoption laws only, that is the CARA, Central
Hmm.
Adoption and Regulation Authority. And
Hmm.
uh, mm, uh, if the current laws explicitly state that only the individual unmarried persons can adopt, the refusal can be seen as consistent with the within the legal framework. The existing adoption rules are designed to respect the religious diversity within the silver land, and altering these rules may infringe upon the rights of religious communities that they may have specific beliefs regarding the marriage and the structure of the family they may constitute.
Okay.
And refusal to allow adoption for LGBTQ couples is not a violation of their rights, as the Central Adoption Authority has the right to establish the eligibility criteria for the prospective adoptive parents based on the existing laws and rules governing adoptions. Your Lordship, there has been various reports as to the drawbacks uh, that have been that have been recognized. What will happen when the child is being adopted by the same sex couples? That is in the paper, child attention deficit hyperactivity disorder
Hmm.
is one of the mental issues that most of the children were facing in US due to under the adoption of the same sex parents. And the paper concluded that the children with same sex parents in the US were twice as likely to suffer from this ADHD disease than the children with opposite sex parents. And
Okay.
the paper titled High School Graduation Rates Among Children of Same Sex Household, uh, it used the consensus of Canada in 2006 to study the high school graduation probabilities of children of parents belonging to the queer community. And the paper concluded that the children living with parents belonging to the queer community performed more poorly in school when compared to the children living with married heterosexual parents.
Okay.
Another paper, which was titled Children in Planned Lesbian Families, Stigmatization, Psychological Adjustment, and Protective Factors. This conducted a study to assess the extent to which the children between 8 years and 12 years in planned lesbian families in Netherlands experienced stigmatization. That is, for the purpose of this assessment, datas were collected from questionnaires through questionnaires filled out by the mothers of those children and also the children as well. So it was after the study, comprehensive study, it was concluded that the higher levels of stigmatization were associated with such children, and boys were found to be more hyperactive, and girls were found to be found to suffer from low self-esteem. Your Lordship, the Council seeks 2 minutes more to
Yes, yes,
proceed with.
yes. Proceed.
Your Lordship, another argument is that the children benefit from the exposure to traditional gender roles, and having both a father and a mother provides a balanced and diverse parenting experience. This is a relief among some individuals that allowing LGBTQ couples to adopt may be seen as a departure from traditional family issues, the erosion of the traditional family issues. So it is essential to engage in them in open and respectful dialogue about what constitutes a supportive family environment. And the children adopted by those LGBTQ couples may face social stigma or discrimination from peers or society, and children should be raised in the families that adhere to these traditional gender family values. And the LGBTQ couples may not provide a normal family environment, which could potentially harm the development of the child. And in the section, additionally, the Kara Authority under the JJ Act has provided that no child shall be given in section 5, clause 3. No child shall be given in adoption to a couple unless they have at least 2 years of stable marital relationship, except
Hmm.
for in the cases relative or step parent adoption.
Hmm.
So uh, denial to adopt the child is nowhere a violation of right to the LGBTQ community.
Okay.
Your Lordship, if it may please Your Lordship, my co-counsel would proceed with further arguments with
Yeah.
issue number 2.
Proceed. Proceed.
Much obliged, Your Lordship.
Your Lordship, am I audible?
Yes. Very clear. I think you have not provided the written submission,
Your Lordship, we have provided.
but the same is not available with me.
Issue number 2.
Yes. Can the court
Your
master clarify in this regard? The issue number 2.
Yes, Your Lordship.
Okay, page number 12.
Page number 12, Your Lordship.
Oh, in this proposition only, you have your submission.
Yes, Your
Okay,
Lordship.
okay. Fine. Proceed.
Uh, Your Lordship, I will proceed with the issue number 2, that is whether same-sex marriage can be recognized legally.
Hmm.
Does Constitution protect their rights? The respondent humbly submits that fundamental rights are defined under Part 3 of the Constitution of India, which are available to her citizens. But
Hmm.
the LGBTQ community creates a complication in the constitutional mechanism, and hence have some rights restricted for the good of the society. In case of in this case, the restriction is on the marriage, since there is no statutes related to this issue by the legislature. So these can be dealt with the judgments by the Supreme Court, as judgments of the Supreme Court can be a law until and unless there is any further legislation by the
Under article?
legislature. Under Article, Your Lordship, under Article 13.
No. 13 speaks about judicial review. Supreme Court is the law of land under article.
Yes,
Okay, 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 okay. You submitted fundamental rights are there for all the citizens. My question
yes, right.
is whether in the meaning of word citizen, the present issue, the LGBTQ,
Yes, your
are
lordship.
included or not in the broader aspect of citizen
Yes, your
LGBTQ, whether they are included or not? Are they coming
uh,
under the purview of word citizen or not? Simple
indeed,
question.
your lordship, they will fall under the ambit of citizenship because in
Okay.
the case law, National Legal Service Authority, it has been mentioned by the Supreme Court that they can be considered the third gender and they can also enjoy all the rights as a normal citizen.
Yes, if there is a right, there is a remedy.
Yes, your lordship.
If there is a right, in case of infringement of their right, they can approach or they can't.
They can approach.
Okay. Here they have approached.
Yes, your lordship.
Okay. So who will protect the rights or their rights other than the constitution?
Sir,
Your
the
issue
Supreme Court.
belongs to this issue, no? You are
Yes,
dealing
your
with
lordship.
this issue.
Yes, your lordship.
The constitution is the law who will uphold the dignity of the fundamental right which are going to be infringed of a citizen
Yes, your lordship.
by way of writs in high courts or supreme court.
Yes, your lordship. Under Article 32 and
In this
26.
case, in this very case, you have submitted the, there is no specific statute or law to that effect. But to speak about the Transgender Protection Act,
In Transgender Protection Act, there is no specific provision related to marriage. In this issue, we have showed the marriage, and here it has been said that whether same-sex marriage can be legalized. Within
hmm,
same-sex, only transgender doesn't fall. Also,
hmm,
gay community, lesbian community, queer community, and all other 72 community, all other
hmm,
72 categories also fall within this. So
hmm.
we cannot confine it only to the transgenders.
Okay.
Also in this case they have said that whether same-sex marriage can be recognized legally.
Hmm,
Here same-sex marriage cannot be legally recognized because if we'll take example, if we'll take for a real life instance, in
hmm.
Canada they have legalized the same-sex marriage since 2005. As we know,
Okay.
that is a developed country, but India is a developing country. There
Okay.
is still scope that people will develop in future. In 2018, the Navjot Singh Johar has uh, decriminalized the consensual sex between two uh, adults of same sex. Similarly, if the situation permits in future, if the all geographical or any other things which will permit the situation, then in that at that time the legislature may take proper appropriate steps to deal with this marriage. So, but at this position, same sex marriage cannot be included because in India there are also staying other religions. The people people in India are awareing day by day about this issue, but they have not completed upgrade. We have seen people related to want to day religion conflicts. They turns into riots and all other dangas and all. If we completely change this, if we completely bring any legislation related same-sex marriage, then we also have to amend or change the further laws in Hindu Marriage Act, in Muslim Marriage Act, also in other acts. So
Who will
bringing
change? Who will
legislature will
change
change.
the law?
Legislature will change.
Okay. Okay.
The In this particular case, the court may issue some direction or guidelines which can be which can give them legal aids, but we cannot give them the proper marriage status at this position of time because it is not the appropriate time.
Okay. Then if they cannot be, they are to be denied of their rights.
Yes, Your
As
Lordship.
guarantee as because of their citizens, they have their own rights. Now you are saying they cannot be given their rights. So they have been denied, they have approached this court. Huh.
Yes, Your Lordship.
If, according to your submission, they will not, that this PIL is not maintainable, then what is the appropriate forum?
Here in this case, it is not a PIL. It is a personal issue that will be filed under a petition or under Article 136. If they would have they would have filed in their subordinate court, they can have just come to the Supreme Court directly. But this is not a matter of public. This is not a matter of PIL because here their personal interest is invested.
But it extends to the entire LGBT community, na? LGBTQI community. The issue
Yes,
will
Your Lordship.
cover this issue will cover the entire LGBT community.
Your Lordship, here marriage, we cannot say marriage is a legal, marriage is a fundamental right because, for instance, if we take two individuals are in relationship and because of some reason one individual denies to marry to other person, in that case the other individual cannot force the first individual to marry her because it is a fundamental right. So in that case more issues and complications will occur.
Okay.
Secondly, in the case,
Do you think civil court is the appropriate forum in which a declaratory suit can be filed regarding the fact that A is the legally wedded wife of B who are transgenders? Do you think civil court is the
yes,
proper forum?
Your Lordship, maybe family court deal with this issue.
Family
Civil
court.
court, yes, Your Lordship.
The suit for declaration is to be filed before civil court.
Your
Family
Lordship.
court deals with what are the powers of family court? Can
So
you
to deal
explain?
with, sir, to deal with the divorce cases or
Yes.
to deal with the um, inheritance of
Issues
properties.
between family,
Yes, Your Lordship.
husband and wife.
Yes,
Okay.
Your Lordship.
But
Yes, Your Lordship.
suit for declaration is only to be filed before civil court. Here, A is claiming to be the legally wedded wife of B, both being belonging to same community, LGBT community. Huh. My question is civil court is appropriate remedy or appropriate forum to be approached in this regard? What is your
Yes,
opinion?
yes, Your Lordship.
Okay. Proceed.
Your Lordship.
Then my simple question again: if civil court will be there for this for their right recognition of their right, then uh, will not be it proper to amend the provisions of Specific Marriage Act
Sir,
because
in
it is not applicable.
your,
HMA is not applicable. HMA is not applicable in this context. Okay,
your Lordship,
we'll go for
yes,
Specific Marriage Act.
Your Lordship, in Specific Marriage Act, in Section 4, Clause C, it has been
Mhm.
mentioned that the age of male and age of female.
Yes.
So, male and female. So here we cannot say that this is there is no mention that other than male and female like transgender and other community. We if the legislature feels it appropriate, they may
Then what is
amend
the
this.
definition of Mr. Counsel? You tell if Specific Marriage Act deals with male and female, then what is the definition of trans man and trans woman?
Trans
What
man.
was my first question to Mr. Counsel of the petitioner?
Yes, Your Lordship. Trans man refers to the people who are who have incurred uh, female sex at the birth, but
Hmm?
with time their behavior and their internal feelings have changed to a man.
Yes.
They are
Absolutely.
trans men, and the vice versa.
Hmm.
In the case
Okay.
of trans men.
Hmm.
You may
So,
proceed.
according to your submission, uh, the Transgender Persons Protection of Rights Bill stands as a barrier to the Constitution of India.
No, Your Lordship, not all fundamental
If,
rights.
according to you, this PIL is not maintainable, Okay. Huh.
Your Lordship.
Because the parties, affected parties, do have other
Yes,
remedies at other
yes, Your Lordship.
forums. Huh.
Yes, Your Lordship.
So the transgender persons protection of right bill is ultra virus.
Your Lordship.
The transgender persons protection of right bill is ultra virus, isn't it?
Your Lordship, no, I don't think it will be ultra vires
Yes.
because transgender right protects their rights. But if we'll see broadly, if we'll protect their rights, then also the other individuals of normal citizens of all other religion, their rights towards practicing a proper religion or other beliefs, there too will be infringed.
Okay.
Yes, Your
Okay.
Lordship.
Proceed. You proceed.
Your, Your Lordship, marriage in India, governed by codified statutory laws and uncodified personal laws, neither of which recognize same sex marriage. These
Hmm.
laws govern marriage and all rights, duties, and remedies concerning marriage. There is no room for any change in these laws as they immaculately fulfill their constitutional purpose. If we bring any changes to these laws, it will take time. Not in instance case, we cannot say that it is appropriate to bring changes. If the situation changes in future, if the people are aware or they are more educated about the things in these regards, then at that time the legislature may take appropriate steps, or the Supreme Court may issue some guidelines at that, some more other guidelines at that point of time. But in conclusion, the council would humbly submit that at this position, at this particular time, it can the same sex marriage cannot be recognized because it is not permissible due to the uh, situation of geographical situation or any other religious situation in the country.
Okay. 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 Thank you very much.
Your Lordship. Your Lordship, if permits, we may proceed with the prayer.
Yes. Yes. Yes.
Uh, Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly submitted. It is humbly requested that this honorable court may be pleased to adjudge and declare that the PL is not maintainable under Article 32 of the Constitution. A declaration may be made to the effect that any differentiation based on sexual orientation is not in the violation of Article 14, 15, 19, and 21 of the Constitution. Refusal to provide legal recognition to the marriage between the same sex or transgender couples and right to adopt be held a non-violative of fundamental rights, and or pass any such order, writ, or direction of as the honorable court deems fit and proper. For this, respondent shall duty bound pray.
Okay. Okay. Is
Your
there any
Honor,
rebuttal from the side of
Your Honor,
petitioner?
the council seeks permission for rebuttal.
Yes. Proceed.
Much obliged, Your Honor. Your Honors, our learned counsels for the respondents have stated that in presence of an alternative remedy, a PIL cannot be filed before the Supreme Court. But Your
Hmm.
Honors, an alternative remedy is a rule of convenience, not of law. As it was stated in the case of Ramesh Thapar versus Union of India, that
Yes.
the presence of an alternative remedy is not a bar in the case of gross injustice and sheer violation of the fundamental rights of the citizens of the nation. Thereby,
Hmm.
our petition under Article 32 before the Supreme Court is completely maintainable. Further, Your
Okay.
Honors, it has been upheld that there is a substantial question, there is a complex question which is to be addressed by the Supreme Court. Thereby, our petition is moved as a PIL under Article 32, where the fundamental rights of not only a particular section but LGBTQIA plus community as a whole is to be considered. Further, Your Honors, the learned respondents have stated that they are in the consideration that LGBTQIA plus community have to be provided certain fundamental rights, whereby curbing certain other fundamental rights. But Your Honors, through several judgments of the Supreme Court, it has to be considered that fundamental rights have to be considered as a whole and not as a part. The state
Yes.
could not ensure that only a certain part of the fundamental right could be guaranteed, whereas the others could be curbed out. Moving ahead, Your Honors, the learned respondents also stated that under Article 15, the restriction or the non-grant or denial is on the basis of or on the ground of gender, whereas not on the ground of sexual orientation. But Your Honors, LGBTQIA plus community identify themselves and this is a sexual orientation, and the infringement is completely on the basis of sexual orientation, which is violative
Mhm.
of their right under Article 15, which was also stated in the case of Navdeep Singh Johar versus Union of India, that any infringement basing upon their sexual orientation is a violation of their fundamental rights. Also, Your Honors, they have addressed under page 14 the eligibility with regards to unmarried couple and
Mhm.
the married couple. But here,
Hmm.
Your Honors, the non grant of adoption rights, which is completely not addressed by the respondents. They have just skipped the issues and have not addressed the issues of adoption rights as well as the issue of LIC claim, which have been claimed by the petitioners. Also, Your Honors, the reports that they have presented in regards to the international reports as to the
Mhm.
LGBTQIA plus community could not be considered as binding upon a nation like Silverland, which is full of diversity and a sovereign nation, abiding by its preamble. Thereby, presentment of or reliance on such reports, such international reports, is of no validity, Your Honors. Also, Your Honors, in the other arguments, they have stated that children who are been adopted by the LGBTQIA plus community, there are reports that there is development of certain kinds of diseases or mental issues in them. Your Honors, it is a sheer defamation against these communities where it is stated without any basis, without any reasonable grounds, that there is cases of mental issues among those children who have been reared and nurtured by the LGBTQIA plus community. Rather, there are no positive grounds on which their contentions are based upon. Thereby, Your Honors, considering all these grounds, it is stated that they are just not considering the fundamental rights that our clients have provided under the Constitution of Silverland, and their contentions are completely are based on non-reliance upon these fundamental rights, non-regards to the fundamental rights, and they are also not considering the basic personal rights that we have as a community, because our PIL is not only as a personal spirited case that we are presenting before the Honorable Supreme Court, but it is the voice of the majority of the citizens of the nation of Silverland that we are presenting before this Honorable Supreme Court. Thereby, their contentions could not be held to be valid, and there is a sheer violation of the fundamental rights of our clients, Your Honor.
Okay. You are seeking a declaration from this court that Chandler is married to Monica, right?
Your Honor.
Huh? Isn't it?
Your Honor. Indeed, Your Honor.
Okay, okay, okay. Is Supreme Court a valid court to declare uh, that a person is a legally wedded wife of another person?
Your
Can
Honors,
Supreme Court give a declaration to that effect?
okay. Your Honors, we are not just considering with the civil right of the individual, but we are also we are before this Honorable Supreme Court in regards to their fundamental right as to the recognition of marriage between every same-sex couple of this nation. Thereby, it is not only in spirit of a personal right of Monica and Chandler, but also to all those LGBTQIA plus community couples who are not been recognized under this consideration that their marriage is not valid, Your Honors.
Okay.
Much obliged, Your Honor.
Any further rebuttal from the side of respondents?
Your Lordship, may we seek 2 minutes for discussion with my co-counsel?
Yeah. Okay. Okay.
Much obliged, Your Lordship.
In the meantime, I will ask my brother judge, Mr. Kumar, to ask any question, if any, to the councils.
Yes, there was a term that was being used by both the sides. It's mostly they're using the term same-sex marriage.
Yeah.
The
Yes.
question that I wanted to ask is there a difference between sexual orientation and gender identity, or it's the same thing?
Yes. Counsel for the petitioner.
Uh,
Please, yes.
uh, Indeed, Your Lordship, the difference between gender identity and sexual orientation was the question of reliance in the case of Navtesh Singh Johar case, where they discussed like what will come under sexual orientation and what will come under the gender identity. So while discussing that matter, the court come into the conclusion that when we are discussing a sexual orientation of a person, it will be a mindset or the physical characteristics that has been characterized like transgender men, transgender women, lesbian, gay, bisexual, atypical sexuals. These are all the other categories, including the plus, includes more than 150 other sexual orientations that has to be taken into consideration. After placing a reliance and connecting what is a sexual orientation, the court further identified that gender identity is the criteria that has to be established in regards to sexual orientation itself. So they have made a connection that gender identity and sexual orientation has no such major difference in that regard. A minor thin lining is on the just a basis of the pronouncement that we take upon. Gender identity and sexual orientation are almost and majorly similar as held in the Navtesh Singh Johar case.
Thank you.
Okay. Uh, in all these matters, it has been referred to apply uniform civil codes throughout the territory of India, right? So my question is, will not it be proper to say it's a gender equality code instead of uniform civil code? You got my point, Mr. Counsel. Will it not be proper to term the UCC as gender equality code, not uniform civil code?
Uh, no, if we consider stating as gender civil code, it will be a
Gender equality code, not gender
gender
civil code.
gender
Yes,
equality code, Your Lordship.
yes.
And it is a complete dissimulation and violation of Article 15, it does say, that says that there is no discrimination on gender basis. So it will be directly impacting upon Article 15. But if we say uniform civil code, it is considering every person in that regard. That say it is a normal person, it is a transgender person, or person of any other sexual orientation. Every person in that regard will be coming under the category under umbrella of a same law, and that will protect the main concept behind the golden triangle, considering Article 14, that is equality before law and equal protection of law. So thereby stating that gender protection law or gender equality protection law or gender equality right, that is a sheer violation of Article 15. And uniform civil code or uniform legal code is a better and the very correct interpretation or very correct terminology that should be used for a law that protects the equality of every citizen in the country.
Okay. Thank you very much.
Indeed, Your Lordship.
Counsels for respondents, are you prepared?
Yes, Your Lordship. Your Lordship, answering to their questions, they asked that the PIL is not maintainable, as we are contended that the PIL is not maintainable as there are already alternative remedies available. In a recent case in the Bombay High Court declared that the PIL is only maintainable in a case where all the alternative remedies have been applied to the needs of the
Existed. Where
petitioner.
all the
And
remedies have been exhausted,
yes,
then
Your
the
Lordship.
remedy lies with in the shape of PIL.
Yes, Your Lordship.
Okay, okay, yes.
Lordship. And regarding the discrimination relating to the sexual orientation and not gender or the gender identity, Your Lordship, the council seeks pardon as this is a typographical error. It is the discrimination based on sexual orientation and not the gender identity.
Okay, okay.
And another thing, the Supreme in the case Supriyo Chakravarti versus Union of India, it was
Mhm.
held that the right to marry is not a fundamental right, neither it is an absolute right. So it cannot be
Mm.
protected by the Supreme Court itself and be guaranteed towards
Okay,
the LGBTQ community. Since in the purview of the queer community, there are 72 other genders, which is totally impossible to be interpreted by the court, as there may be so many commutations and combinations arising from those 72 genders. So it is totally a complex situation that is impossible to be interpreted by the court. And in case if it is interpreted, that would definitely lead to the violation and affection to the towards the other personal laws and religious practices as well.
okay. Thank you very much.
Your lordship, if the bench gives permission, then we would go for the rebuttal round. Sir, rebuttal round.
Rebuttal.
Sir, rebuttal round.
It's over. You have submitted to that effect.
Your lordship, there are some counter
Anything left?
questions.
Anything left? Anything left?
Your lordship, the respondent side is supposed to ask the questions to the petitioner.
Is it so? Could it be clarified by the court master, please?
Am I audible, sir?
Yes.
Am I audible, sir?
Yes. Yes.
We extend our deepest appreciation to our esteemed judges for their invaluable contribution and insights. Your guidance has not only
No,
enriched
no, no,
this
no.
competition.
I think I asked you whether the respondents could be asked to submit their questions to the petitioners in sir rebuttal round.
Sir, I have to consult my senior. 1 minute.
Please, please, please. In the meantime, what will be your suggestion, Miss Counsel, for the respondent?
नहीं सर କିଛି ଗୋଟେ ପଚାରୁଛନ୍ତି କି କଣ ସବମିଟ୍ କରିବାକୁ ଥିଲା ପିଟିସନ କରିଛନ୍ତି କି ନାହିଁ ସବମିଟ୍ କଥା ହେଇଯିବ ମୋ ସହିତ ସିନିୟରଙ୍କ ସହିତ
Please
କନସଲ୍ଟ
unmute. Please unmute.
Am I audible? Your lordship,
Hmm.
shall I proceed with the questions if the permission is granted?
Yes, yes, yes.
Your lordship,
এই
the
ରିପୋର୍ଟଟା
Huh?
କରୁଛନ୍ତି କ୍ୱେଶ୍ଚିନ୍
No, no. My question to the court master is whether there is any rule to that effect. Counsel for the petitioner can question certain points to the counsel for petitioner or vice versa in rebuttal or sir rebuttal round.
So it's for rebuttals only. They can only object. There are no such provision regarding to the other person to answer that question, but they
Yes.
can only object.
Yes, yes, yes. Okay. Thank you for the clarification.
your lordship, if it may please you, shall I proceed?
I think it's not in the rule. Okay.
Okay, your
It's not in
lordship.
the rule. Okay. Before parting, I must say best wishes
to all the participants, all the council. Thank you very much.
Thank you so much.
But sir, they can object. Your lordships, I want to clarify. They can object on the basis of the memorial that they have found this.
They
This.
have done. They have done this. They have done this.
Anyone have any doubts, or we move to the last segment of this quarterfinal round? All right. As we end this session, we would like to extend our deepest appreciation to our esteemed judge, Mr. Shah, for their invaluable contribution and insights. Your guidance has not only enriched this competition but has also left an inevitable mark on the minds of all our participants. It's evident from these sessions also, and we are immensely grateful for your generosity in sparing the time, valuable time for us. Thank you so much, sir, for your valuable time. We are
Welcome.
deeply